Hello, my name is Cecil Smith, and this presentation is called You Should Know This, Ordinances and Regulations That Can Get You into Trouble. This was first presented in 2012 at the Minnesota Multi-Housing Association's Independence Day, and both myself, Cornerstone Property Professionals, and the Minnesota Multi-Housing Association assume no responsibility and suggest that you get legal advice on any of the matters raised in this presentation. The first of our top 10 regs that you should know. Caretakers must be covered by workers' compensation and unemployment insurance. You should be treating your caretakers as employees. It's very easy to try and think, well, they're independent contractors and I can avoid a lot of complications and paperwork and liability with that, but if you are breaking any of the conditions stipulated in statute that determines what is an employee or an independent contractor, and they are very specific, then you should be treating your caretakers as employees. And in addition to that, your employees should be subject to unemployment insurance and paying the necessary taxes on that. The fines for not having unemployment insurance and in addition to that workers' compensation insurance are steep. It's $1,000 per employee per week for the period of time that the employee was not insured. Number 9 of our top 10 regs. The Caretakers management background check must be done for anyone who's entering your units, has access to master keys, anything like that that enables them to enter the unit. This background check is meant to exclude individuals with a sexual violent criminal history from entering into your residence units. The criminal history must be clean for 10 years from any sentence discharge. The BCA oversees this process, and we certainly want to encourage you to make sure this happens for the protection of your tenants and your own liability. Number 8. HUD has a lead disclosure statement for all pre-1978 residential transactions. You typically see this on sale of property, but it also has to accompany any lease. And HUD says the disclosure to the there is a responsibility to disclose to the lessee the presence of any known lead-based paint or any known lead-based paint hazards in such housing and provide to the lessee any lead hazard evaluation report available to the lessor. In other words, you need to be completely transparent about your property and any lead-based paint or hazards on your property. You're also required to provide the EPA pamphlet on lead hazards at every transaction, and on the form that the HUD suggests you use, there is even a place to notify for the tenant to indicate that they have received that pamphlet. HUD is enforcing this. As of earlier this year, Northeast Housing LLC faced a fine of $153,000 on 13 leases that lacked a disclosure statement. Number 7, working through to number 1. You should obtain and post your city rental license. Certainly in the city of Minneapolis, landlords are required to post their rental license, and they're also required to post the 331 poster in the common areas of each building. That carries a $500 fine and a $200 fine respectively. Also, you are required by state law to post notice of proposed property taxes for property taxes payable in November of each year. That's when we all get our estimated property taxes, and the list of hearing dates, we're meant to pass that on to all of our tenants. Number 6, application fees require a written rental policy disclosure and only one application fee at a time. You must disclose criteria to any prospective tenant on which what the decision criteria is to rent to that particular tenant, and that needs to be consistent and uniform in accordance with all fair housing laws. You have to notify the applicant with 14 days if you reject a rental application and identify the criteria in your written rental policy that they failed to meet. Landlord must not use cash or deposit an applicant's screening fee until all prior applicants have been either screened, rejected, or offered the unit and declined to enter into a rental agreement. So you're really only using one application fee at a time until that person's brought right through the process. Then you can touch a second application fee. Otherwise, and in our practice is not to collect more than one on any one apartment. Number 5, there's to be no fee-based management in Minnesota without a Minnesota real estate broker license. The Minnesota Department of Commerce is the enforcement agency on this, and they frequently issue cease and desist orders. The initial penalty as initial penalty and the fines that accompany that order have ranged last year from $750 to $7,500, but it's also punishable by a gross misdemeanor. This means you can't manage in Minnesota for a fee for another any property unless you have a Minnesota real estate broker's license, not a salesperson's license, but a broker license. And this also includes situations where there are other owners of a property who are not brokers, and you are managing for a fee for those other owners, and perhaps a partnership or whatever. So, no fee-based management without a Minnesota real estate broker license. Number 4, Minnesota requires a disclosure of tenants' rights. Minnesota statute specifies that landlords are to notify residential tenants that the Minnesota Attorney General Landlord Tenant Handbook is available to them. This needs to be made known to all of your tenants that they have tenants' rights and how they can understand those tenants' rights, where they can obtain this information from. That's all required by the landlord, and we make sure that this is happening at lease signing, and there should be postings as well. Heading down the home stretch on our top 10 regs that you should know. Number 3, this is a serious one, federal, state, and local fair housing laws. The federal and state and local laws tell us that race, sex, religion, familial status, disability, national origin, color, creed, sexual orientation, marital status, public assistance, ancestry in Minneapolis and St. Paul, and age in St. Paul cannot be used as criteria in any evaluation for housing, for placement in housing, for services in housing. These are all protected classes. So, my suggestion is keep current on these. The case law on each of these protected status continues to change, particularly on disability. And it's a good idea to take a fair housing leasing class every 2 years to keep current on this. If you have a broker's license, that's required. Keep current on these issues. This is a moving target for landlords, and we need to be refreshed again and again on these matters. Just a reminder here, a reasonable accommodation for a disability does not have to be explicitly requested. If it's in any way inferred, then you have to pursue a reasonable accommodation for their tenant. They don't have to use the language, I'm requesting a reasonable accommodation. And never ask if a person has a disability or about the nature or severity of a disability. It might seem a caring and interested question, but it is considered discriminatory under federal fair housing laws. And remember, the maximum penalties are $16,000 for the first violation, $65,000 if you get to a third violation within 7 years, plus victim compensation and legal costs that can be imposed by the federal government. And it does not include the possibility of civil lawsuits which would follow. The number 2 top 10 regulation. Follow the repair, renovate and paint rule for lead-based surfaces. This is relatively new in the last few years. This rule came into being through the EPA that says any interior surface disturbance, painting, scraping, heat treatment of more than 6 square feet on a pre-1978 residential structure must follow the repair, renovate and paint safe work practices rules. If it's an exterior surface, the disturbance must be limited to 20 square feet to avoid following the rule. So anytime you're working with more than 6 square feet, any interior, more than 20 square feet exterior, you need to be using a certified renovator. There's all kinds of disclosures and notifications that need to happen to tenants while the work is going on, and there is a whole process of safe lead work practices, all the documentation that has to follow. It is quite significant. However, don't try and avoid this. March of this year, a rental property owner of a fourplex who was responsible for the building operation and maintenance agreed to a $10,000 fine for uncertified exterior repainting. And this had a trickle-on effect because this man has now been referred to OSHA because he hired some guys to do the repainting, and of course they were repainting in a lead-based paint environment, and there's all kinds of worker protection rules that have to be in place as well. So he's just got done with the first round with the EPA, and OSHA is going to deal with him next. And the number 1 top 10 reg you should know: smoke detectors, alarms, CO detectors, fire extinguishers. These are required in properties. And smoke detectors and alarms need to be in and outside bedrooms on new construction, older construction, without any renovation having occurred in the bedrooms. Can still just have alarms outside the bedrooms, but again, check the rules. These keep changing. As we saw with the introduction of the state mandate for CO detectors outside bedrooms. Fire extinguishers, if you have them, need to be tested annually, that they're in proper working order. And your testing service has to be certified. And eventually the extinguishers will be cycled through on a replacement basis. There is an exception on the CO detection, which we have actually instituted. It's not commonly used, but we think it's very cost effective because CO detectors are so expensive, and that is centrally monitored. So you can have CO detection that's centrally monitored at all points of combustion. So if you just have a laundry room and a boiler room in your property, then put CO detectors in them, have them centrally monitored, and you do not have to be concerned about CO detection inside the units because there's no points of combustion that might generate a CO2 hazard, a CO hazard I should say. So there we have the top 10 regs landlords should know. These are the tricks for weary travelers in our industry, and we certainly encourage you to follow up, read all the rules and statutes and ordinances. We're giving you all the references here, and then pay attention to these issues because they do keep changing. As you know, the government writes lots of rules and regulations, and it's our business to know them and adhere to them. Thank you very much.